Hello, my name is Michael Tessera and I prepared this presentation entitled The Deceased, His Wife, the Developer and His Lawyer. And I'll be looking at the case of Kimberley Developments Proprietary Limited and Bale, which is a New South Wales Court of Appeal case which came down recently, which looked at a range of different issues, but I guess from a competition and consumer perspective, the main interest is in relation to the finding of unconscionability. And I guess the title is reminiscent of that movie that people may remember, The Cook, the Thief, His Wife and Her Lover. I guess in the sense that this is a very intricate range of relationships. In this particular case, it reminded me of that particular movie by Peter Greenaway many years ago. Now, a bit about myself. I'm a competition and consumer lawyer, and I've been running my own practice, Tessera Legal Consulting, for the last 15 years, and I help companies and individuals with competition and consumer law problems. And I also do some consulting work for some legal publishers on competition and consumer matters, including LexisNexis, CCH, Wolters Kluwer. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline to the case, it's Kimberley Developments Proprietary Limited and Bale, and the Court of Appeal decision was handed down by Leeming, Kirk and Griffiths. But the primary judgment has been written by Leeming, and both Kirk and Griffiths agreed. And this was an appeal from a decision of Justice Ward at first instance. So that outlined the presentation. I'll start with the background, then look at the facts, the decision. I'll have a little bit of a look at this legal cost issue which arose, and then finish with some commentary. Now, the dramatis personae of this particular case is set out there. The deceased is Michael Sheen. He was the person who owned the relevant properties. There was his wife, Miss China Sheen. There was a developer, Mr. Albert Darwich, and finally his lawyer, Mr. Martin Churchill. So they're the four people: the deceased, his wife, the developer, and the developer's lawyer. Now, there's quite a bit of background, but I'll go through it. It's important to understand this. Mr. Sheen died in April 2021. He was aged 90. And Miss Bale, Francois Bale, was his daughter, and the only daughter from his first marriage. Mr. Sheen's first wife died in 2006, and he remarried Miss China Sheen when he was about 77 years old in 2008. In 2009, he sold his home in Gordon for $1.3 million, and then he moved to Woolgoolga down south with his wife, and they lived down there. It was a strange thing, this third man, Miss Max Moore, he lived with Miss Sheen and Mr. Sheen in their house in Woolgoolga. And it was a sort of strange thing. It was mentioned in the case, but didn't seem to have any particularly significance. But the real estate agent who was managing some of Mr. Sheen's properties that were generating rentals were directed by Miss Sheen to transfer that rental property revenue into Mr. Mo's account. So that's just mentioned in the case. I don't quite understand why it's there. And then in 2016, Miss Sheen separated from her husband. Now, before Mr. Sheen retired, he ran his engineering company and had a business located in Forest Lodge. And at the time of the disputes, when they arose, the property was tenanted and generating, obviously, rental income. And there was a mortgage with Suncorp over the property in Forest Lodge. And the debt wasn't huge, like it had been quite high previously, but at the time of the transaction, it had been reduced to $263,000. Having said that, Mr. Sheen was having some financial difficulties meeting the repayments, and there was a little bit of a risk of the bank seeking to recover the property. There was also an attempt to sell the business, and there was various estimates of what it was worth. There was some promotional material that suggested it was worth $600,000. Having said that, it was put for auction, and I think they got an offer of $650,000, and Mr. Sheen believed it was worth about $1 million. You'd think a property in Forest Lodge would be worth in excess of $1 million. And then finally, in 2010, this Mr. Darwich became aware of the Forest Lodge property. So Mr. Darwich enters the scene in 2010. Now, Mr. Darwich set up this company called Kimberley Developments in 2011, and Mr. Darwich was the sole director and shareholder. And a proposal was arrived at where Kimberley Developments and Mr. Sheen would form a joint venture. And the idea was that Mr. Darwich would pay Mr. Sheen some money, and then the Kimberley Developments would develop the property and obviously reap some profits from that development. This formal joint venture agreement was drafted by the lawyer, Mr. Churchill, who I'll come to shortly. It wasn't a very good document, and it was signed by Mr. and Mrs. Sheen. It wasn't actually signed by Mr. Darwich, and that led to a conclusion. Also, given the way the agreement was written, that it had actually no legally binding effect. But as a result of this joint venture agreement, things occurred. So the first thing, that there was a transfer of the property to Kimberley Developments for a total value of $590,000. And as you can see, the transfer of the title of the Forest Lodge property to Kimberley Developments was registered in 2011. And Mr. Darwich was associated with another individual, Arthur Trigus, who had a business called Superstart Batteries. So effectively, when the joint venture agreement was signed, the property was transferred to Kimberley Developments, and Mr. Trigus paid out the mortgage to Suncorp from his company Superstart Batteries, and he paid out $288,000 to clear that particular mortgage. So there are a number of relevant findings made by the primary judge that weren't contested in this particular case. The first, it was Miss Sheen had been sued for breach of a fiduciary duty. So she had a power of attorney over Mr. Sheen's properties, and at the primary judge level, she was found to be liable to the state in order to indemnify it for the breach of a fiduciary duty. Kimberley Developments was found to have held the Forest Lodge property on a constructive trust, clearly because Miss Sheen breached her fiduciary duties. So that was for the benefit of Mr. Sheen or his estate. And when Super Batteries, Mr. Triggers's company, discharged the mortgage and obtained the title over the land, they immediately mortgaged the property to NAB to borrow monies, which went to the benefit of Mr. Triggers and Superstar Batteries. And then the final observation there, Superstar Batteries and Mr. Triggers, as knowing recipients of trust money, were liable to repay Kimberley Developments as a constructive trustee for Mr. Sheen. So it's all very complicated, as you can see. Now, a key issue here was that the transfer of the property was signed by three people, and as the judge commented, one has died, Mr. Sheen, one cannot be found, Mrs. Sheen, and the third party is in prison and unable to give evidence. So as you can see, Mr. Sheen died and was unable to give any evidence, obviously, about the terms of the agreement and the signature of the transfer. His wife, China Sheen, had separated from the husband previously, and they said had disappeared. I'm not sure if she's actually off the face of the earth, I think, but obviously wasn't playing any role in these particular proceedings. And then finally, the developer's company solicitor, Mr. Martin Churchill, who may be a name that lawyers are quite familiar with, was on trial and in custody, having been refused bail, and he was facing charges including the participation in the supply of a commercial quantity of prohibited drugs, taking part in a criminal group. So you may recall the story where the Sydney lawyer was charged with running a drug ring through the Supermax prisoner Bassam Hamzi. And so the allegation there was that effectively Mr. Churchill was visiting his client, Mr. Bassam Hamzi, who is well known as the founder of the Brothers for Life gang, and communicating messages from Mr. Hamzi to people outside in order to run the drug business that Mr. Hamzi was accused of being involved in. And it was quite interesting the way that things were communicated. They had allegedly code words, and I think one of the code words for drugs was the word barrister, and it was obviously still before the courts. Nobody's been convicted, so these are just allegations at the moment, but it's quite an interesting set of allegations that have been made. So the agreement that was entered into was that Mr. Sheen would receive 60% of this Class B shares in this new company set up by Mr. Darwich, Kimberley Developments. However, those shares were never issued. So, as you can imagine, there was a payment off of the mortgage, and then the balance was supposed to be paid in shares. But there was no record of them ever having been issued to Mr. Sheen. However, both Darwich and Triggers claimed that they actually had paid Mr. Sheen the money in cash, $302,000 paid in cash and given to the deceased and his wife, largely in $100 bills. But there was no receipt for the payment of the $302,000 and there were no banking records. So there were three main issues on appeal. The first one was whether the case upon which Miss Bale succeeded at the primary judge level was outside the pleadings, and if so, was that permissible? Was there any procedural unfairness in allowing her to succeed on a case outside of pleadings? Secondly, were the $302,000 in $100 banknotes ever paid? And thirdly, whether the primary judge was correct in the conclusion that Mr. Sheen suffered from a special disadvantage and was preyed upon by Mr. Darwich, and accordingly the conduct was unconscionable. Now, the first ground's interesting, and I think there's some interesting case law here. It's clearly agreed that the ground on which Miss Bale succeeded at the first instance had not been pleaded, namely this inducement by representation. And it's stated there by Leeming that, the pleadings are important, but the parties may choose to litigate a case outside the pleadings, and that can occur in particular cases. And in this particular situation, Leeming concluded the case based on representation was not only open and cross-examined upon, but really was an argument that arose inevitably from the conclusion that this joint venture agreement had no legal effect. So it was, as he says there, the consequence of the forensic stance adopted by Darwich and Triggers, faced with contemporary documents, that effectively the contractual the legal document was not of any contractual force. And so when a case was argued on the inducement by representation by Miss Bale's counsel, no objection was raised by Darwich or Triggers's counsel that the issue was outside the pleadings. So what Leeming concludes here, that it's not likely to be concluded that the parties are able to succeed on an issue that is outside the pleadings, but he says in the present case, facts are unusual, not least the unpleaded defence that an elderly man was paid $302,000 in cash without documentary record for a conveyance which itself was relatively undocumented. So why is a person parting with their title in a valuable property unless they're being paid some money and some inducement is being put to them as to a reason to part with that valuable asset? So he concludes, Leeming, that this is a case where the parties must be taken to have expanded the issues presented and in their pleadings, and so the primary judge made no error on this particular point. The second appeal ground was whether the money had actually been paid, and there was this interesting comment in one of the defendant's affidavits, and I couldn't help laughing reading it. The defendant's affidavits advanced the case that Mrs. Triggers's father kept a large amount of cash in a safe at home, which was paid to Mr. Sheen on the 21st of February 2011. In cross-examination, Mr. Triggers said, "My father traded in cigarettes. He was a high-end fitter machinist. He had scoop supermarkets. He liked playing cards. My father followed his father. I followed my father, and we always keep cash." So none of them really explaining where the cash came from. It's sort of suggesting that there's a lot of cash floating around the Triggers' households, but not really explaining where $302,000 in $100 bills came from. Now, the primary judge concluded that the appellant's case was implausible, that they would have, paid this elderly man $300,000 in cash, taking no receipt, no photograph of what had been occurring. There were no bank records, and there were no contemporaneous documents. There was no reference to the payment in cash, but instead to the issue of shares. So the judges concluded that it was inherently implausible that the money had been paid to Mr. Sheen in cash. Now, just moving to the third ground, it was whether the conduct was unconscionable, and the primary judge found that the transaction was grossly improvident, and that's based on the conclusion earlier that no money was paid across. Clearly, if Mr. Sheen had received $590,000 for the property, potentially that wasn't considered grossly improvident. But if you're looking at it from the perspective that the $302,000 was never paid, then he has parted with a very valuable property for simply the value of paying out the mortgage. So as you can see there, the judge concluded there was no monetary consideration paid for the sale of his only remaining asset. He had had a previous offer of $650,000 from this Mr. Moore, so why would he sell a property that he knows is worth at least $650,000 for $288,000? He received roughly half the proceeds of what the property was worth. So based on the fact that the transaction on its face looked grossly improvident, the onus now shifts to the Mr. Darwich and Kimberley developments and the people who obtained the benefit to provide evidence to the court to prove that the transaction was fair, just and reasonable, to show that the transaction was not unconscientious. Now, the decision of the Court of Appeal was also that the primary judge's decision was correct. The transaction was grossly improvident. The agreement included an 80-year-old man losing the ability to earn income from his property. So, as mentioned earlier, this property was being tenanted, and he was obtaining rent. And so he lost that benefit, and all he got in return was a potential share in the profits of a development in a company. No other consideration apart from the payment of the mortgage out. And on the facts found, Mr. Sheen received the benefit of monetary consideration that was less than half of the nominated sale price of the land. So putting all those factors together, the Court of Appeal was satisfied that the transaction of the sale of the land for less than $300,000 was grossly improvident. I also noted the primary judge's observation that the transaction was unconscionable and that Mr. Darwich could not displace the presumption that it was an unconscionable dealing. So she concluded that Mr. Darwich maybe wasn't aware of Mr. Sheen's declining cognitive ability. There was some evidence that he suffering from Alzheimer's disease, but whilst there couldn't be proved that Mr. Darwich knew about that, he was aware of the deceased age. He was also aware that Mr. Sheen was in significant financial difficulty finding enough money to pay the mortgage payments. He received no independent legal advice. The only lawyer involved in the whole transaction was actually the lawyer for Mr. Darwich, Mr. Churchill, and he was actually the person signing various agreements as a witness. So Justice Ward concluded at the primary trial level that this amounted to knowledge of the special disadvantage of Mr. Sheen and that he was vulnerable to exploitation. And so she found that the defendants, Mr. Darwich and Kimberley Developments, had unconscientiously exploited Mr. Sheen's special disadvantage. The appeal court agreed. It said there that the fact that Mr. Sheen was prepared to proceed to transfer title to the land without independent legal advice, without the usual incidents of a conveyance, and in circumstances where, aside from the written and oral representations reflected in that agreement, which is to be found of no legal effect, all that was received was a discharge of the existing indebtedness, which on any view was substantially less than the value of the Forest Lodge property, and it makes it plain that Mr. Sheen was labouring under a special disadvantage, which was unconscionably exploited by Mr. Darwich, in which the court will intervene. So the disposition of the case was clearly in favour of Miss Bale, but it was somewhat confusing due to the fact that Mr. Churchill had compromised the claim against him previously. So effectively, Mr. Churchill had been sued by Miss Bale for negligence and breach of fiduciary duty, and decided to compromise the claims, but not unsurprisingly, and made a payment of $350,000. So you'd think at that stage that Miss Bale has received the damages she lost from the transaction. So she's supposed to receive $302,000, but didn't receive that. But here received $350,000 from Mr. Churchill. But it wasn't really that clear. And I think the fact here is that what happened to that $350,000 when she received it as a result of Mr. Churchill compromising the claim. And as you can see there appears to be no dispute that when the case was compromised and $350,000 was paid, all that money went immediately to Miss Bale's lawyers. $300,000 went to the barrister appearing in the case, and $50,000 to the law firm. So $350,000 has come in one hand and gone straight out to the lawyers, which raised some concerns in the minds of the judges, which I'll deal with in a little while. So here's the judge thinking, well, I can't just leave it at this level. There seems to be a lot of strange things occurring here. They're very significant legal costs for a fairly simple matter. So he notes that, there were 3 appellants to this case, plus Miss Sheen, who are required to account to Miss Bale for what occurred. So clearly the amounts paid to Suncorp to discharge the initial mortgage, the benefits derived from the transfer. So this is the fact that Super Start Batteries mortgaged the land immediately to NAB and received a loan, which is obviously a benefit from the transfer. And as said earlier, the property was being tenanted and rent was being paid. So who got the benefit of that income during the period that it was in the possession of Kimberley Developments? So there's quite a bit of accounting that needed to be done just to work out who paid what to whom and all the rest of it. So the court actually decided to lift the stay on the transfer of the property and to transfer it back to Miss Bale. So Miss Bale has the property. She's the owner of the property now, and the parties have to come back to the court to try and explain who should pay what to whom. And so clearly the concern of the court, I think, was that they didn't think the property was worth $600,000. They thought it was worth a lot more. And really, it would be unconscientious to allow Kimberley Developments to, engage in this conduct, unconscionable conduct, get the value of the property and then benefit. Say the property is worth $1 million or $1.5 million now. Should they get the benefit of that, or should effectively Mr. Sheen's estate get the benefit of that? And I think that's why the matter was not resolved at this stage with the accounting of the $302,000 not received against the $350,000 from the Churchill settlement. Now, one observation the court makes, which I think probably have the lawyers who acted for Miss Bale a little bit concerned, and what he said, and I just read it out because it is a very good observation. Ultimately, he's concerned, or he's troubled, at how the solicitor-client costs in this litigation could be anything like $579,000. So here you've got a dispute for $302,000, and the lawyers have charged $579,000. Surely the amount you spend on litigation should bear some relationship to the amount of money at stake. You shouldn't be spending twice as much money litigating an issue where the dispute's only about half that amount. So as you can see, 579,000 was charged for the work until December 2020, plus the cost of a 6-day trial, which the plaintiff was represented by a junior counsel, so not a senior counsel. He's doubtful that the solicitor-client costs incurred by Ms. Bale for the entire proceeding could be 350,000. I reiterate that at present these doubts are based merely on the facts that the plaintiff ran a case for rescission of a relatively small parcel of land, calling 2 witnesses, and the defendants call 3 witnesses. So it seems that when the matter comes back to court, not only are all the transactions going to be looked at between the various parties, but I think the court's going to be looking very closely at the costs claimed by the lawyer and barrister on this case. So just some final commentary. It's a complicated case. There's a lot of ins and outs, and I think the court did well to sort of get to the heart of what's going on and understood what happened. It's an unusual situation where everybody who probably has the best knowledge about the transaction are not available. So you have one person who's passed away, one person who's ostensibly vanished, and one who's in remand awaiting a jury trial. The unpleaded case decision is, I think that's important law, effectively the circumstances in which a person or a plaintiff or a defendant can succeed in an unpleaded case. And clearly, if it's raised and put forward and there's no objection, then that can be enough to allow it to go forward. The unconscionable conduct decision fairly routine, I guess. It's interesting, you look at the value of the transaction. It all hinged on whether $302,000 had been paid. The court was sceptical as to whether the money had been paid. And once it concluded the money had been paid, clearly selling a property of this value for the discharge of the mortgage was seen as grossly improvident. The onus went back on the appellants, Darwich and Kimberley Developments, to prove that it wasn't unconscionable, and I think they failed in that. Clearly, the value of the transaction is a big consideration, but the elderly position of the client, of the Mr. Sheen, the fact he was in financial difficulties, but clearly the fact that there was no independent legal advice, and the only lawyer involved in the transaction was the lawyer for the developer. There's a big concern about legal costs, and I think it's going to be interesting to see what any future decision says about that. I think it's a big issue where lawyers charge much too much for legal services in litigation. Somebody receives a settlement and that money immediately goes to the lawyers to continue the claim is concerning. So I think if I'm the lawyers who represented Miss Bale, I'm going to be a bit anxious about this particular case. The thing that has hit me is whether the money potentially was paid, and which would sort of be ironic if the money had actually been paid to Mr. and Mrs. Sheen and somehow it had vanished. But clearly the appellants weren't able to satisfy the court that it had been paid, and so I think we can rely on that conclusion to come to the view that it wasn't paid. But there's always an element of doubt about that question. So that's all I had. It's a very interesting case. I think probably the unconscionable conduct case is fairly straightforward, but all the ins and outs on the other issues I thought was very interesting. And so it's not a very long judgment, so if you're interested, I encourage you to have a bit of a read of it. And if you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.